Hey, let's talk about ICE, immigration, and enforcement. So it's September 2025, and if you're in the United States, immigration enforcement activity has ticked up quite a bit over the last year, for better or worse. And if you're a business, that means one of two things. The first being a Form I-9 audit, which is a compliance enforcement activity that ICE can conduct. This is less than the second one, which is a raid. A raid is, as you might expect, much more aggressive, breaking down doors, going anywhere they want, looking through everything. So that's a raid, and we'll go over that in another video. So for this video, I want to focus on the Form I-9 audit. Generally, again, this is a compliance measure. It's a little less serious than a raid, but it can have some serious consequences if you don't have good business practices or HR procedures set up, or if you don't respond in a timely manner. Now, one thing to note with these, in a Form I-9 audit, you generally only have 3 business days to respond. So you want to have a lot of your records on hand and ready to go. You want to have your personnel briefed, trained, and ready and understanding how to respond when ICE shows up knocking at your door. So that's what we're going to get into today. I'll call this a training. We have some PowerPoints. I know PowerPoints are the worst. We'll try to keep it interesting, but we'll go through some Form I-9 training today. Okay, so let's get into it. So what is a Form I-9? A Form I-9 is a federal form issued by USCIS. It's used to verify an employee's identity and their work authorization in the United States. As any HR professional knows, anytime you onboard a new employee, the I-9 is something you have to fill out. The employee fills out one part, the company fills out another part. It requires you reviewing certain documents such as a passport, social security card, birth certificate, those types of documents. And it's a pretty basic form. It's kind of a one-pager. There's a couple pages of instructions, but it's pretty standard. And again, any kind of HR person anywhere in the US is familiar with it, but it is important. And when ICE comes knocking at your door with a Form I-9 audit, they're going to ask for all of your Form I-9s for all your current employees and some of your employees that you terminated within the last year. So what does it take to complete the I-9? Pretty basic. The employee completes section 1 of the form on their first day of work. And that's important because that is under federal regulations. It has to be completed by the employee on their first day of work. And then the company, they complete section 2, and they have to do that within 3 business days of the first day of work. Now, completing section 2 is pretty basic, but it generally just requires reviewing the work authorization and identification documents, driver's license, passports, birth certificates, social security cards, those sorts of things. And the company's reviewing them, making sure they're not expired, making sure the names match, the dates, everything aligns, makes sense. There's no major discrepancies. And assuming there isn't and everything's above board, the company completes a few boxes and signs off at the bottom. All right, let's move on to retention periods. You have a completed I-9, you've reviewed the supporting documents, great. The next thing you might want to think about is how you store them, how long you have to store them. And that means, generally, every employer has to keep every I-9 for every employee they've hired for certain time periods. Now, the time period is 3 years from the date of hire or 1 year after the date of termination, whichever one is longer. So that's the I-9 form. Now, the supporting documents, the copies of passports, driver's license, those sorts of things, you're not legally required to keep those on hand or keep copies, but in the case of an I-9 audit or any other type of enforcement investigation, you're probably going to want copies. So ideally, you're going to keep copies of the supporting documents as well as the I-9 form. Keep them in a separate file from the general employee file that allows for easy reference, easy checking, especially if ICE comes knocking, because one of the key parts of an ICE audit is you have to respond within 3 business days. And if you can imagine going through each employee file and digging out their I-9, trying to find the supporting documents if you need them, that is a lot of work. And again, 3 business days isn't long, and they're pretty firm on the deadlines. So ideally, you have the supporting documents and the I-9 in a separate folder, easy to get into, easy to reference, and easy to sort through. Okay, so let's get into what an I-9 audit actually is. We've covered the basics, how to complete one, why they exist, what they're used for, how to save them, and that is, again, that is the basics. Any HR professional will know and understand that. Immigration lawyer will know and understand that. They're part of the onboarding of every new employee, so they're pretty common. But that doesn't mean they're not important, and which is kind of the point of what the audit is for. Again, this is an ICE, sometimes DHS enforcement action, and it is compliant. So they're just making sure, did you do the right things? Are you putting forth a good faith effort, making sure there's no funny business going on? And they are different from a raid. I mean, a raid is a significant step up of enforcement activity. They'll include literally a search warrant signed by a judge coming in, going anywhere in your company, being able to look at any records you have, um, having a lot of force, the force of law, and that is a raid. This is an audit, which is different. It's a step down, but there are significant consequences if you don't comply, if you're not in compliance, and we'll get into that now. Okay, so you come into work, and on your desk is a fancy letter that says notice of inspection. Uh-oh. What does that mean? That means you just got served with a notice from ICE that they intend to perform an I-9 audit. Now, what is an I-9 audit? At the beginning, it is basically gathering all your documents, and then ICE is going to review them. So that means an employee list, current employees, and those employees terminated within the last year, generally, a list or copies and actuals of all your I-9 forms, and if you have them, supporting documentation, you have to gather those up and present those to ICE, and they're going to review them. I mean, that is an audit, but that's what's going on here. The scope of an audit can differ, from industry to company, but generally that's what they're looking for. And there are strict timelines. So once you receive the NOI, you're going to have 3 business days to comply, and that means gathering everything, the employee list, if you don't already have it compiled, that should be easy. Your HR team or whatever HR software you have should be able to do that easily. Gathering the I-9s, depending on how your onboarding procedures are, how your record keeping procedures are, could be difficult, especially if you start going through them and you see some errors, missing signatures, misaligned dates, outdated documentation, expired documentation. Those are the things that ICE is looking for. And if you start going through and seeing, errors, omissions, um, you're going to have a long few days, that's for sure. But that's generally how it starts. Again, it's the notice of inspection. And you don't want to take the deadlines lightly. They're pretty firm. Generally, there are no automatic extensions. And when extensions are granted, it's usually reserved for extraordinary circumstances, natural disasters, major technical issues, those sorts of things. Um, and if an employer, company fails to produce whatever's requested, including the I-9 forms, of course, within the deadline, ICE can treat those missing forms as if they never completed them at all. And that's a very serious violation if that's the way ICE treats it. Again, so if you have 500 employees and you don't produce them for 300, not because you don't necessarily not have them, but just you didn't meet the deadline, ICE could treat those 300 employees as if they never had I-9s, which would be a very serious violation. And those are situations where you see the fines, the civil fines and fees rack up really quickly because usually it's per violation. So imagine, $3,000 fine multiplied by 300 employees. Obviously, it gets pretty serious for any employer that's going through an I-9 audit. So we kind of touched on this in the previous slide, but what is ICE looking for? First, completeness. They're checking for missing fields, incorrect dates, improper signatures, signatures that don't match, signatures that are missing, those sorts of things. Number 2, timeliness. Again, the deadlines are important. That is something they'll be sticklers on. Section 1, completed on the first day of work. Section 2, completed by the employer within three days. Those are important to meet. Number 3 is document validity. So, I mean, when you go through a passport, a driver's license, any kind of supporting documentation, you gotta do a good check, a good faith effort. Now you don't have to be a forensic, you know, document reviewer. You're not looking for that, but you got to show that you made a good faith effort to verify that the information was not fraudulent, was accurate. We'll go over that a little bit in more detail later in this training. But I mean, we all know what a passport looks like. We know the type of paper it's printed on. We know the type of typeface it has. If you look at a passport and the picture is totally wrong, it looks like it's taped in there. There's weird, whiteout or the print changes or it just looks like it was, modified. Those are things that ICE expects you to catch. So they'll be checking for that. And number four, retention compliance. Again, the timelines and deadlines are important. Like any kind of compliance, it's kind of a pain in the butt. Some of it may not make any logical sense or reasonable business sense, but they are what they are. So again, 3 years from the date of hire or, at least 1 year after termination, whichever is longer. If any employee falls within that time frame, you better have an I-9 on record. Okay, so you have the NOI, you've gone through, your disclosure process, sharing all the documents for review and audit by ICE. What happens next? Once you get through the main audit process, they will issue a notice of findings. And this is basically ICE's official notice to you, the company, saying what they found. You may get a letter of compliance. That's the best case scenario for your company. That basically says, yes, we've audited you and we found you to be in compliance. That's great, right? That's what you're looking for. You could get a warning notice, which means we found significant material errors, but we're going to let it slide this time. I mean, you'll probably get audited again, but no enforcement action, no penalties, no fines, no fees. It's a warning. That's okay, but be ready to do some more work over the next few years to make sure, some of those issues were cleaned up and taken care of because ICE more than likely will come back and check. The worst one is a notice of intent to fine. That means there was significant wrongdoing, significant errors, and your company will be fined, or at least they will issue fines. There is a settlement procedure or process you can go through, but it means at some point your company has done something that ICE deems really bad, and they're going to fine you for it. So the liability part. Now, in an ICE audit, even though it is a compliance enforcement action, there is both civil liability and criminal liability. So we'll go over the civil liability first. Key thing with all of this, it's per violation, which means basically either per I-9, per employee. If you have a lot of significant errors on a single I-9, it could be per error within an I-9. So as you can imagine, the fees can add up really quickly, and your company could be fined liable for a lot of fines, fees, and damages, things no company wants to deal with, right? So there's generally two types of violations. There's paperwork violations, and there's knowingly hiring or continuing to employ unauthorized workers. I think you can probably guess what the second means, but we'll go over each right now. So paperwork violations, mistakes, omissions on the I-9 form, you didn't sign. There's a missing section. You didn't fill it out completely. For those types of issues, fines currently range from $288 on the low end to $2,861 on the high end, and again, that's per violation. Stepping it up to another level of seriousness, knowingly hiring or continuing to employ unauthorized workers. These are more serious violations, obviously. This speaks to intent. Someone either told someone to do something wrong or someone knew what the rules were and went the other way on them. And there's a lot of intent. And ICE obviously doesn't look like that, right? If you intended to break the law, well, we're going to hammer you a little harder, right? So these are more serious, and they increase for repeated offenders. So first offense ranges on fine $716 to $5,724. Second offense $5,000 to $14,000. Third offense $8,000 to $28,000 per violation. So you can imagine, in the worst case scenario, at $28,000 a pop, that stings, right? And obviously it's intended to, because someone's knowingly breaking immigration law. Uh, Now, ICE will consider different factors, right? I mean, there's a range for a reason. They want some flexibility. Now, if you're a company, you have some serious errors, but in all, it looks like you either had one rogue employee or there were issues a while ago. You fixed them. You have new processes, new procedures. And again, you're in the paperwork violation world. That fine is probably going to be closer to the $288 range than the high end, right? On the other hand, if there's bad faith by the employer, if there are executives and managers knowingly, going against immigration law to try to get ahead, well, you're going to be on the much worse end of that fine scale for sure. Okay, criminal liability, obviously worse, but this is where fines kind of turn into crimes, right? And fines do come along, but crimes mean you could go to prison. Not great. Now, most Form I-9 audits, they only lead to civil fines, most of them. It's pretty rare for actual, criminal liability to come up unless it's deserved. I mean, it just doesn't happen that often. But they can happen. I mean, inspection by ICE can lead to the Department of Justice getting involved and prosecutions happening. The key thing on criminal liability is a pattern or practice, which again speaks to the intent, speaks to the severity of the actions. But generally, a pattern or practice, it involves repeated intentional conduct as opposed to your isolated mistakes. Now, the criminal investigation, if it's kicked up to a notch from like an audit to an investigation of a criminal nature, they're going to interview your HR staff. They're going to interview your managers. They're going to interview your executives, maybe. They're going to interview everybody they think they need to with the power of subpoena, with law. I mean, it is forceful. I mean, it's very hard to say no to these types of investigations. They're going to subpoena payroll information, tax records, again, everything that you could imagine that relates to the employee relationship with the company, having their work done, how they're paid, which goes back to their work authorization. They're going to coordinate with the Department of Justice because ultimately the DOJ, if it gets bad, will be the one prosecuting the case. Now, the criminal penalties, they're pretty severe. They can be. Again, they're rare, but they happen. They do happen. So don't want to like make it sound like they don't, but it is a little rare. Pattern or practice violations, they can result with fines up to $3,000 per unauthorized worker and imprisonment up to 6 months. Employers, again, this is real intent and kind of a lot of successive bad actions, but if you're found to be concealing, harboring, or shielding unauthorized workers, especially with knowledge and intent, fines can range from anywhere from $10,000 to $250,000 and sentences from 6 months all the way up to 20 years. Um, this can affect, you know, your lower level HR managers or even HR staff or anyone else involved, all the way up to the executive, CEO, CFO, anyone who knew, anyone who colluded, anyone who had any kind of plan or conspiracy to break immigration laws, could be hit with this criminal liability. Now, beyond the criminal and the civil liability, there's other consequences. One of the main ones being publicity. So, this is reputational damage. This is you being on, your local news, your company being out there that's saying ICE raided your place or ICE conducted an audit and it resulted with deportations, fines, criminal liability. I mean, you don't want your company name associated with those types of news stories, right? Um, on an operational side, if a lot of your employees are found or deemed to be unauthorized and you lose half your workforce, especially on your manual labor side, if you say manufacturing or farming or agriculture, well, your operations just got cut in half and you got to spend time, money, effort to replace those workers. In the short to midterm, obviously that's a huge impact, right? Moving forward to the future, you're going to have increased scrutiny. So if you fail an audit or you fail badly or there's, or worse, for the next, 3, 5, 6, 7 years, ICE is going to give you more scrutiny. It probably means at least another audit, if not more, which will be, continuing until you start showing some real compliance with immigration laws. And finally, if you're any company that works in federal contracting, you could be debarred. So, disbarment means you can't qualify for any federal contract. So any companies that work or want to work, in federal contracting, you want to comply with your immigration laws. So that's the bad things that can happen, right? Let's go on to how we can prepare, how we can try to maintain compliance, how to make sure we do this right. So first, you're gonna want to take time and do an internal audit of your I-9s. Every HR person who's watching this just sighed heavily. Um, Anyone in the compliance department probably just sighed heavily. But it's something you're going to want to do, especially if you're in an industry that is more likely to be audited. So, I mean, again, this is manufacturing, this is agriculture, this is staffing agencies, this is anywhere where, think about where you may hire, say, immigrant workers. Unfortunately, ICE knows this, call it profiling, call it stereotyping, whatever you want, but they will target certain industries more than others. And if you're in one of those industries, you absolutely should do an internal audit, ideally annually. I know that's a lot, but ideally it is annual to check everything, make sure your process is right, make sure your retention's right, the way you save documents, um, your staff, make sure they're trained. They know, I mean, if you ever onboard a new employee, if anyone's ever done this, I mean, there's probably 15 documents that you go through. You got your NDA, a non-compete if you use one, your benefits form, all that stuff. It's all part of the onboarding process. The I-9 is part of it, and you don't want to underestimate how important it is. Um, as we stated earlier, you want to make sure your I-9s are saved separately from the employee file. Any supporting documents for the I-9, again, saved in a separate file, somewhere that's easy to reference, easy to sort through if ICE ever comes knocking on your door. Um, Additionally, you're going to want a audit response plan. So again, you only have 3 business days to deliver what ICE is looking for when you get a notice of inspection. To do that, ideally, you're going to have a response plan, and that's going to include designating a point person. You're going to manage the team that's responsible. They're going to manage the whole operations, kind of be the point, the quarterback, and handle all interactions with ICE. There will be some back and forth, going through with ICE, with various details. Like, here's all of ours from I-9s from, the last 3 years, ideally, right? Hey, we're missing it for this guy. This is why. ICE will evaluate that. They may ask for something else. They may say, okay, we understand. That's fine. You're going to want a key point person to work through those issues with ICE. Um, you'll want a set response protocol. So who do you contact? How do you let them in? Do you, does anyone, or you should train your people to know, okay, if it's a certain type of warrant, there's a judicial warrant where, it carries a little bit more force than an administrative warrant, which we'll go through in a second here. And who's going to gather the documents? Who's actually going to go in and gather all these documents? Who's going to review them? Are you going to review them before you give them to ICE? Those sorts of things. And then obviously, you're going to want to consult with legal counsel. If you have an in-house lawyer, wonderful. Call him or her up, let them know what's going on. I'm sure they'll be able to give you some good direction, detailed direction. And if you don't, call your outside counsel immediately. You're going to want legal assistance and support, if not outright guidance and leadership, when you're going through an audit. Now, back to the warrants. When ICE does come knocking on your door, generally you're going to have one of 2 types of warrants. There could be a judicial warrant or an administrative warrant. Now, a judicial warrant is issued by a federal state judge or a magistrate. Um, it has a strong level of legal authority. It's generally based on probable cause. It's backed by the Fourth Amendment. And as far as scope, generally it allows ICE to enter non-public areas of your business. They can seize records. They can detain individuals. They can detain employees. They can question people. And again, generally, as an employer, if you're served with the judicial warrant, you have to comply with kind of whatever it says, up to the scope of what it states in the warrant, but you have to comply if it's judicial warrant. Now, a lighter version of that is an administrative warrant. Now, these are usually signed by an ICE administrative officer, not a judge. It's based on the Immigration and Nationality Act. It's not reviewed by a judge. It's not signed by a judge. And the scope of these are generally narrow. And practically speaking, it means that ICE cannot enter into non-public areas of your business. They can't seize records. They can't detain people. Um, Again, it is like judicial warrant light. They can do less things. It has less force, but you want to be able to identify that. And as part of your, your protocol, your response plan, you're going to want to have training for whoever is going to review the warrant to understand that the difference between a judicial and administrative warrant. So, some tips for internal audits. So, um, maybe with some donuts, some pizza parties, whatever it might be, you got your HR and your compliance team on board to do an internal audit. Wonderful. It is a good part of any kind of immigration law compliance program, and it'll help ensure you're ready and are in compliance if ICE comes to your business. So when you're performing an internal audit, you want to check each I-9 for missing information. Basically, you're going to do what ICE would do. Signatures, data, dates, all those things. Check it all, make sure it's generally accurate. Check the supporting documents if you take copies of them. No funny business with the passports, the driver's license, the visas. The names got to match, the date of birth's got to match, all that sort of stuff, right? Um, you're also going to want to maintain an audit log. So ideally, you do your internal audit and everything's perfect. That would be wonderful, right? What's more likely to happen is you're going to find a handful of errors, probably minor mistakes, unintentional things that happen as you onboard employees. They happen. So you maintain an audit log, and for minor things, you can cross them off, write in the proper information, initial it, date it, and that's generally okay. In the audit log, you'll track what you did. So when ICE comes and looks at it, again, if this is before an audit, that shows good faith. Uh, you know, it's less good faith if they knock and then it's dated the day after they gave you the notice of inspection. That shows less good faith. But if you do this beforehand, yeah, it's like, yes, we did it. We want to make sure we're in compliance. We checked this 6 months ago, and this is how we fixed it, right? That's great. I think that's good, and you want to track that in an audit log. Um, for more significant errors, let's say you had a bad employee 2 years ago who did not know anything about I-9 forms. They did everything wrong. For more serious errors, you're basically just going to do an I-9 again. Do the whole I-9, the whole process for that employee, do it the right way, and just attach it to the original I-9. Again, if you're doing this before an audit, it shows good faith. Um, Finally, you're going to want to check out E-Verify. E-Verify is basically a federal system that verifies immigration and work authorization eligibility across the federal database, which means, the federal government didn't put a stamp of approval on it, but it's pretty close to that when ICE checks it. If you use E-Verify, this I-9 audit, the issue and the risk goes down significantly. Finally, you're also obviously going to want to train your hiring managers. I mean, any good hiring manager knows everything in this. I mean, your hiring manager should probably be able to give this training a little better than I am because they're in it every day. They know the details, they know the ins and outs. But every good hiring manager, whether they're new or seasoned, should know this. Most of your HR team, any part of the onboarding process, they should know this. Your compliance officer should know this. And then obviously, if you have legal support, someone in the legal team should be familiar with these laws as well. All right, so that concludes this Form I-9 audit training. Hopefully you found it helpful, and if you did, please subscribe, and we'll see you on the next one. Thanks.